could we be allowed officially by these files being called so that we are together? We still feel that we are excluded when we are before you.
In which petition? In which petition?
There is petition 5 E570,
okay.
E550, E549.
In E509, and associate myself with the submissions made by my learned senior counsel Paul Moite and the ones made by my learned friend senior Kibe. Your Lordship, to the best of our knowledge, in the matter E015, when we broke yesterday, there was a promise by the court, and the court has kept that promise, that we shall be coming for a ruling of the application that was made. Yesterday I indicated to the court, Your Lordship, that this court was constituted to deal with the consolidated petitions E522 consolidated, and now E565 consolidated. And we have been issued the notice that my learned friend Mr. Omari is referring to, that he also seized of 4 other matters: E570, E550, E541, and E572. Your Lordship, the notice that was issued to us indicated that we are coming for a mention in respect to those particular files. I hope the court is in possession of this notice, so that the court may refer to the same. Subsequent to which, Your Lordship, will be seeking your guidance on how we deal with the applications filed therein. For example, pursuant to my client's instructions, we filed an application dated the 22nd of October for the recusal of the bench. We would wish that subsequent to the court addressing and acknowledging that the other files before it, that I get directions on how to dispose of my application, for which, Your Lordship, the application was served. I wish to take directions exclusively and specifically on that particular matter.
My lords, may it please you, I hate to interrupt, but this is most unforeseen. We are all counsel of some reasonable experience. We all appreciate, some of them here are very senior advocates, very senior counsel. The file before the court is the only file in which you can make an application. The court cannot make orders in files that are not before them. All these files physically brought to the court are not before court. They will be before court when they are called out by your legal assistant as being available for the court to make orders. We therefore object to this manner of conducting these proceedings. It is our very humble submission that it is yet another attempt to delay the expeditious disposal of this matter.
Your Lordship, very briefly.
If I may, my Lord.
Yes.
There are matters that you have certified as urgent and that you have identified as being urgent. And I say this with a very heavy heart. My learned colleagues for the petitioners have been engaging in this dilatory tactic since yesterday. There are 2 applications before you that are certified as urgent. There are several other matters that have applications that perhaps have not been certified as urgent. Perhaps your lordships may be kind enough to deal with those urgent applications, and these matters can be dealt with later on. The files may be here, but they are not before the court.
Okay, you have talked enough.
So on this side we have.
Yes.
Council on that side appears to be taking the whole of it.
Because they stand much. Just speak, Mr. Mwete. If you want to be heard, just speak. We'll listen to you.
I'm asking.
Yes.
For equity of power.
We.
All time to council on this side.
They stand and speak. You also just stand and speak. We have not stopped you for standing. Yes, speak.
I think for purposes of clarity,
Yesterday, when we started hearing on the issue of validity of the bench, which has now been disposed by the ruling in red. The question that they wanted was the application for the validity plus the issue to do with the recusal being handed together. The understanding of the court and ourselves was that they cannot be dealt with together. So that the second preliminary issues after the issue of the validity of the bench has been disposed of are the three pending, are they three? Actually, I don't know about two. Three applications for recusal. Those are preliminary issues and they relate to the same consolidated matters that this court has given a ruling on. That is issue number one. Issue number two, my lord, that is important to be noted. Yes, the consolidated file that is before you has that applications for recusal. That's what my learned colleague is emphasizing. So the second business of the court was supposed to be that one. But more importantly, my lord, so that we do not want to hear these accusations about, oh, somebody is trying to delay this matter. We are the victim. And I reiterate that. For purposes of the petitions before you, we would like this petition had as a solicitor. And we kept on saying yesterday, the petitions to be had. My lord, these rules, because it's the enforcement of the constitution, the Mutunga rules applies. Since the Mutunga rules applies, the applications of the Mutunga rules was everybody was supposed to respond even to the petition to get the matters rolling. There have been no compliance with Mutunga rules for purposes of the respondent. So that if anybody was to be accused of any delay, it would be somebody who has not complied with the Mutunga rules. That is issue number one. Issue number two, my lord, was this, that even for purposes of consolidation, the consolidated matters, some of the advocates led by my colleague, Mrs. Kimogo, they were not even served with the applications that the respondents are itching to have them disposed of. So that, my lord, because of that mess that was created as of yesterday, and the fact that we do have now a notice talking about these matters, the truth of the matter is, unless we have a situation where some of the advocates in the four matters that were not there yesterday have not even been served with this notice, and I know them. So that unless now we take a fresh date without somebody waiting to say that, oh, this court must discharge orders and we have a swearing in over the weekend, the truth of the matter is we need a clear date where the court ensures everybody who ought to be before you, particularly based on these issues that has been raised courtesy of correspondence with the Chief Justice, is addressed. But somebody to pretend, oh, I want to lift the conservatory order and the other side is delaying, it is unfair. We want the petition heard, and it starts with compliance with the Mutunga rules, which there is no compliance whatsoever by the respondents. So that, my lord, I beg you that let us not appear now to be saying, oh, somebody is playing to the gallery. Nobody is playing to the gallery. We just want to assert everybody's rights. And these rights are very easy to enforce if the Mutunga rules are going to guide these proceedings. My lord, I beg you to have the information of that.
Your Lordship, I had just wanted to highlight the content of the notice which you received.
I think we'll talk about the notice. I said let's sit down. We want to talk about that notice. I will talk about that notice before you speak.
My Lord, do I have your permission to address the court?
And even if the court wants to talk, you don't want the court to talk. Dr. Camino, let me address the issue of the notice.
Oh, sorry. I apologize.
Please.
I apologize.
I think we have made it very clear in the ruling which you have just delivered that the matters before this court are very important to the people of this republic. And you will appreciate that petitions are still being filed throughout Kenya. When we retired yesterday, we received several empanelment of matters which of which we gave this notice. Therefore, don't think you are the only person who are in these petitions. There are also other Kenyans who are coming day in, night out. So the matters which you've set out for mention are the matters in which we have been empaneled as from yesterday. So you wait for court to give directions, then you start talking. You cannot just start talking from the air without facts. Let us mention these files first, then from there you'll see the directions emerging, and then you can make your prayers. Let's mention these files first. The other clarification is that we have two cohorts of petitions which have been consolidated. The first cohort were the petitions which were filed to challenge the processes both in Parliament, yes. And during that time, this bench consolidated 6 petitions.